What is the stage of the trial? Prosecution shall take steps to summon the witnesses. Are they fixed for evidence? Yes.
Binson,
Here, Your Honor, the wife of the witness came and informed Your Honor that the witness, Elias Takha, had expired. She's the wife.
Yes. What is it?
The witness had expired, Your Honor. The wife of the witness.
No, that information will not do. You have to bring death certificate.
Yes, I've told her. She told that on the 29th they'll be getting it. So I told her to.
Okay. But in the meantime, we can summon some other witnesses.
Okay, yes.
Accused Binson Papeng.
Papeng.
Present along with defense counsel T. Lambang, prosecutor Sri D. Lambang present. Prosecutor informed the court that the witness Sri Elias Dakha expired when?
Country Iklabu Kurumbi. Arbana. 22nd January 2024.
Expired on 22nd 01/2024. The prosecution shall produce death certificate of the witness. Prosecution is at liberty to summon other witnesses. Fixed for evidence.
Jarisnyo, Ponsitum, Santios.
One witness.
Who?
Victim.
What case is this?
376.
Same case.
Yes.
Examiner on the last day, the first witness. Just two victims in this case.
Where is the victim? Then we have to take in camera.
Yes. She's there.
We'll take in camera.
Yes.
Later part.
Okay.
Yes.
Kepat bah.
Will appear through BC.
Who?
IO.
Where is? Where is he?
He'll call me, sir, because he said he's on the way to the court. So he'll call me when
The court will wait for the witness, or witness will wait for the court?
it's the witness.
All right, since he's appeared, we can examine him. Yes. Next.
Ritu Melempena.
Your Honor, the summon to the IO, I confirmed it on the report that the concerned officer is on leave.
Permanent leave.
It's only mentioned that 60 days.
Temporary leave or permanent leave?
Temporary.
Huh?
Temporary.
She is the only witness left.
Yes, sir. She's on.
Is she genuinely on leave or she's avoiding the court?
For that, Your Honor.
60 days is from when? Till when?
It's not mentioned there, Your Honor, since when from.
Huh?
It's only mentioned 60 days.
But what are we supposed to do? It's for you to clarify. If we have to issue summon to her again,
Okay, I will.
when will we fix the date?
Okay,
Again, we'll fix the date when she's on leave.
I'll call her.
This period of 60 days commences from when and it ends when? That has to be made very clear.
I will seek clarification on that.
What case is this?
316.
Since when this matter, or who's filed this application? Since when this application, this matter is fixed for evidence of the IO?
It's more than 6 days. Since last year.
Where is she now?
I don't know, Your Honor.
Huh? This matter is fixed for examination of the IO since 31/7/2025. Prosecution has failed to examine the prosecution has failed to examine the IO for almost a year. To stop. Someone issued to the IO returned with a report that the IO is on earned leave for a period of 60 days commencing from 4th May 2026. Where is she posted?
July.
The prosecution shall file a detailed report justifying the non-appearance of the IO for a period of 1 year. This matter will come up again after a week. You file a report. You talk to her. What happened from this, then we'll see.
Okay.
All right. Fix for report by the prosecution. We'll see. Give you all the medical reports. Yes.
It's more.
Right.
Augustine.
1 minute, sir. She came just now. I need to brief her.
The accused are present.
See. And what about the other accused persons?
He informed us yesterday that he was not keeping well, so
Vanda Abdhar, he's absconder.
Absconding.
Who are the accused persons present before this court today?
this not. And, this it move along. It's not, and the other one is.
Who are the three accused persons present before this court today?
Augustine Sana, Edris Sana, and Edmund and Livingstone Sana is absent.
Witness there?
Yes, sir. She came just now.
Yes.
Wilson Pawa.
He also one witness, sister.
Where is the accused?
He's UDP.
Who is the witness?
Witness, he is a member of UDP.
This witness is for what purpose?
He's being informed of the incident, and then he went to the PO and escorted the accused.
Yes.
Dalam khar.
Fixed for what?
Fixed for judgment now.
Where is fine? In the chain of evidence, there is a ring of truth and it connects the dot. The conduct of the accused, which is relevant fact, only fortifies the circumstantial evidence. Non-recovery of the weapon used for commission of the offence is not fatal for the prosecution case, inasmuch as the post-mortem examination report and the inquest report firmly establishes that the injury on the body of the deceased was caused by a sharp weapon. The explanation given by the accused under 313 of CRPC appears to be an afterthought bereft of truth. The prosecution has established that the accused had encountered the deceased over a land dispute which led to fight between the accused and the deceased, and in the fight, the accused caused a fatal injury to the deceased. From the evidence of PW3, it emerges that the accused had a fight with the deceased on a dispute over the land. The evidence of PW7 first IO reveals that the accused was extracting charcoal in the jungle. The deceased appeared and picked up a quarrel possession of the land, which led to scuffle, and in the scuffle, the deceased died. PW8, who had filed the charge sheet, stated that during the investigation, he found that the accused was busy collecting firewood. The deceased appeared and they had heated argument. The deceased took a machete and tried to strike on the accused. The accused overpowered the deceased, and in the struggle, the accused snatched the machete and struck the deceased. Thereafter, he ran home and confessed to his family members. Further, PW8 has also revealed that the deceased was the aggressor. Prosecution has established that the accused had caused injury to the deceased. The act of the accused, with all certainty, is homicide. From the evidence which is unfolded during trial, there is no whisper from where inference can be drawn that the accused had intention to cause death or cause such bodily injury as is likely to cause death. The injury inflicted by the accused found in Exhibit 2 and Exhibit 5 clearly demonstrates that he had knowledge if an injury is inflicted on the vital part of the body, it is likely to cause death. However, there was no intention to cause death. Absence of intention becomes more firm after looking into the genesis of the crime, that is, land dispute. The nature of injury found in the body of the deceased also reveals the absence of intention. It is one single blow which caused cut injury stretching from the ear to the cheek, resulting in death. The accused had inflicted injury on Rising Star Dakar with the knowledge that it may likely to cause death without the intention to cause death. This court finds that the accused had committed culpable homicide not amounting to murder under Part 2 of Section 304 IPC. The accused is found guilty for an offence of culpable homicide not amounting to murder and convicted under Part 2 of Section 304 IPC. ठीक है जी. Tell. You want hearing sentence today? Huh? Today you want?
Yes, let me tomorrow.
Today only.
You will get the copy of judgment. It's up to you if you want today, tomorrow, any day. All right. The accused Helen Dakar present, along with the State Defense Counsel as Jimpart. It is prosecutor present. Judgment delivered in open court in presence of the accused in a separate sheet which runs in 38 pages. The accused found guilty for an offence of culpable homicide not amounting to murder and convicted under Section 304 under Part 2, Section 304. The accused, who is on bail, is taken into custody. Bail bond of the accused stands revoked. Fix this matter for hearing on sentence. Copy of the judgment of conviction shall be supplied free of cost to the accused. When do you want for hearing on?
Do the after later. Okay.
You inform him, the accused, he's convict, keep him separate. GC Mara, this for judgment.
Yes.
Keep him separately, he's convict. In a case which has traveled for 29 years, evidence is bound to get eroded as memory will fade, witnesses witnesses will die. Nevertheless, this court has to determine the charge with the available evidence on record. No doubt, vital witnesses could not be examined as such as the IO officer who filed the charge sheet, witnesses who were present when the incident took place. Non-examination of vital witnesses would not mechanically lead to failure of the prosecution case if there are other sufficient evidence. This court finds that the FIR, which is the starting point of the investigation filed by the PW1, was never exhibited by the prosecution during the course of trial. FIR is not a substantive piece of evidence. PW1 has deposed before this court that she had filed an FIR. The fact disclosed by PW1 in her evidence reveals that she had filed an FIR alleging murder of her son while the son was in custody of the accused person at Daliang outpost. From the evidence of PW1, it emerges that her son came home intoxicated and the police arrived at her house and took her son. From the evidence of PW8, who is an eyewitness, it emerges that PW1 and her daughter went to Daliang outpost and made a request to the police to apprehend her son, who was creating trouble in the house under the influence of alcohol. The accused directed Constable O. Champa and PW8 to go to the house of the lady and bring the son to the outpost. The evidence of the witness PW8 corroborates with his statement under section 164 CRPC. Further, PW8 stated in his evidence that on reaching the house of the lady, they found the son was sitting in the kitchen and he was identified by PW1. The son was taken to Daliang outpost and he was under the influence of alcohol and aggressive towards PW8. PW1 accompanied son to the outpost. It is not a case where the police abruptly picked up the son of PW1. Son of PW1 was apprehended and brought to Daliang outpost on the request of PW1. The defense has warmly contended that the evidence of PW1 is full of exaggeration. This court finds indeed there is an exaggeration on part of PW1, who is the mother of the deceased. However, the exaggeration is not to the extent which will make this court disbelieve the evidence of PW8. The maxim of falsus in and falsus in omnibus, false in one thing, false in everything, is neither a sound rule of law nor a rule of practice. Hardly one comes across a witness whose evidence does not contain grain of untruth or at any rate exaggeration, embroideries or embellishment. It is therefore the duty of the court to scrutinize the evidence carefully and in terms of the felicitous metaphor, separate the grain from the chaff. It is established principle of criminal law in India that an account of detecting some falsehood in the statement of the witness who is otherwise consistent and reliable, his or her entire testimony cannot be discarded. That on scrutiny of the evidence of PW1, this court finds PW1 has exaggerated that the police randomly picked up her son from the house without any rhyme or reason. This exaggeration does not disturb the core fact of the prosecution case that the son of PW1 was taken to Daliang outpost on that ill-fated day. The evidence of PW8 reveals police went to the house of PW1 and apprehended the son of PW1 on the request of PW1. The evidence of PW8 is of sterling quality and corroborates with his statement under section 164. The evidence of PW8 remains unimpeded after being cross-examined. From the evidence of PW8, it is established that the son of PW1 was taken to Raliang police outpost on 16/11/1997 from his house, and he was in custody of the Raliang outpost. Here again, this court would like to emphasize evidence has to be weighed, not to be counted, is a rule which provides its quality of the evidence or the evidentiary value of the evidence which matters and not the quantity of the evidence. It is reiterated that the evidence of PW8 is of sterling quality and there is no plausible reasons to disbelieve PW8. Prosecution has established that the deceased was in custody of the accused on 16/11/1997 at Raliang outpost. PW1 had accompanied her son to the police outpost when he was taken by PW8. PW1 stated that the accused had beaten her son, thereafter poured a bucket of water and again started beating him. PW1 further stated that the accused continued beating her son in spite of PW1 pleading for pardoning her. In cross-examination, she stated that I saw the accused beating my son and I saw him beating my son with lathi. PW8 star witness in the instant case stated in his evidence that the officer in charge was under the influence of alcohol as he had thrown party on being transferred to Knoxtown. He saw the accused hitting the victim with a stick on his body. In cross-examination, PW8 stated that young man was brought to the thana. The OC asked the constable to bring a bamboo stick which was there in the thana. The OC used the bamboo stick to hit the man on his back. The above evidence clearly establishes that the accused PW8 and PW1 were present in the outpost. The accused asked for a bamboo stick and hit the victim with a bamboo stick. After hitting the victim, the accused realized that the victim had suffered injury. As such, the victim was taken to Laskin CHC for medical examination. The evidence of PW1 and PW8 corroborates that the victim was taken to Laskin CHC for medical examination. However, he could not be medically examined as the doctor was not available and they decided to take him to Joy Civil Hospital. The evidence of PW1 and 8 established that the accused had hit the deceased while he was in custody of the accused and thereafter he was taken to Laskin PHC for medical examination. PW1 and 8 saw the accused beating the victim with a lathi. PW1 stated in his evidence that the accused, after beating the victim, poured a bucket of water and thereafter he started beating him again. PW1 pleaded for pardoning her son. The accused did not give any heed to the request of PW1. PW8 stated in his evidence that the officer in charge was under the influence of alcohol. He called for a bamboo stick from the constable and started to hit the victim on his body and told him not to create trouble. PW8 has stated in his evidence that the accused hit the victim on his back. The young man was drunk, aggressive, and abusive. The accused had hit the victim in order to control him. The evidence of PW8 reveals that the deceased was hit with a bamboo stick on his back. The postmortem report, Exhibit 1, reveals that there was a hemorrhage at the maxillary region and multiple abrasions on the back side of the body and both arms. The victim was drunk, aggressive. There is evidence that the accused had hit on the back of the victim with a bamboo stick. The medical evidence also shows multiple abrasions on the back side of the body and the arms. The cause of death was due to shock resulting from intracranial hemorrhage and head injury. There are evidence to show that the accused hit on the back of the victim, and the medical evidence supports that the victim was hit on the back. But the cause of death was not due to the injury on the back and the arms, but because of the head injury which led to the intracranial hemorrhage. It will be necessary for this court to meticulously examine the autopsy report. At the end of every autopsy, all the facts, history, and findings has to be reviewed to see whether they fit together. The purpose of medico-legal autopsy is to establish the cause of death and to decide whether it is due to the natural or unnatural cause. It must be remembered that the cause of death eventually recorded should be the condition which led to the death of a person. Coming back to the evidence of the doctor who conducted the autopsy, it is found that the deceased suffered hemorrhage on the maxillary region, multiple laceration on the back side of the body and both arms. There was a swelling outside the skull on the left side and the right side. There was a depressed fracture on the right parietal region and involved the brain. The injury found by the doctor on the body of the deceased are as hereunder: hematoma on the left maxillary region, multiple abrasion on the back, multiple abrasion on the both leg, abrasion on both arm. The word hematoma means solid swelling clotted both within the tissues. Maxillary region consists of a pair of maxillary bones forming the upper jaw, mid-face, roof of the mouth, floor of the orbit, and the side wall of the nasal cavity. In case of homicide by a lathi, bamboo stick, weapon is frequently absent from the scene except in domestic cases. The pathologist must try to ascertain the weapon used from his examination of the nature of the injury. In the case in hand, there is an eyewitness PW8 who saw the accused landing lathi blow all over the body of the deceased, including the maxillary region. The external wound reveals the point of impact, and it also reproduces the whole or part of the leading surface of the weapon used. It also reveals indication of the position of the deceased in relation to the assailant. The evidence of PW1 reveals that the accused unleashed severe lathi blow on the victim, and thereafter he poured water with a bucket, and once again he started beating the victim with lathi. The victim has suffered on his arms and maxillary region. It is natural when a person is hit over his body with a bamboo stick, through his reflex action, he would try to cover his face and head with his hand. The deceased had suffered injury on his back, arms, maxillary region, and also on his head. There was a depressed fracture on the parietal region. The medical evidence clearly reveals injuries on the head, maxillary region, and arms. The injury on the head led to intercranial hemorrhage and caused his death. When there is an eyewitness to the incident, non-seizure of the weapon would not dislodge the prosecution case. The statement of the accused under section 313 of CRPC is not an evidence. However, it provides additional link to the prosecution case if the accused fails to reasonably explain or makes a false statement. The accused affirmed that the victim was brought to the Raliang outpost. The explanation advanced by the accused that the victim was brought to the police station with an injury all over his body and with a torn shirt, if read in the teeth of the evidence of PWA, it distinctly demonstrates that it is an afterthought and a blatant lie, which only provides additional link to the prosecution case. The prosecution has established that the accused had inflicted bodily injury and caused death of Emerson Tarian. The accused has committed culpable homicide. Now this court is called upon to answer the degree of culpable homicide. The evidence of PW8 reveals that PW1 along with her daughter appeared at the Raliang outpost with a request to apprehend her son who was creating trouble at home. Officer in charge of the Raliang outpost accused directed PW8 and the UB Champa to go to the house of the lady PW1 and to bring the son. The house of the lady was within the walking distance from the police outpost. The lady accompanied PW8 to her house. PW8 found the son was sitting in the kitchen and he was identified by PW1. The son was taken to the outpost. The son of PW1 was under the influence of alcohol. He was aggressive towards PW8. PW8 saw the accused hitting the victim with a bamboo stick. PW8 in cross-examination stated that the victim was aggressive and abusive. The victim was hit by the accused with an intention to control him. This is not a case where the police randomly picked up the victim and physically abused him in custody. It is a case where the mother of the victim made a complaint in the police outpost against the victim who was creating trouble in the house. The police acted on the complaint of the mother of the victim and brought the victim to the outpost, who was drunk and abusive. The accused had hit the victim with a bamboo stick all over his body as he was aggressive and abusive. Law permits police to use force for the purpose of apprehending and controlling apprehended person. However, the use of force should be proportionate and not excessive. In the case in hand, the accused used disproportionate force to control the victim, leading to death, which is evident from the autopsy report Exhibit 1. The accused, in his lawful exercise of power, had taken the victim in custody. However, he had disproportionately exercised his power to control the victim who was drunk and aggressive by inflicting injuries on his body using bamboo stick. There are also evidence which has come through PW8 that the accused was under the influence of alcohol, as he had thrown a party on being transferred, which only goes to show that the accused was charged up. The evidence on record does not manifest that the accused had caused injury with an intention to cause death of the victim. The accused had hit the victim with an intention to control his aggression. This is not a case where the accused had hit the victim with an intention and knowledge that the injury would cause death. This is evident from the fact that the accused, after hitting the victim, immediately took him for medical examination. Unfortunately, he could not be medically examined at Latskin CHC as a doctor was not available. The accused was kept in the lockup with his injuries and he died. This is not the highest degree of culpable homicide. The accused had knowledge that unleashing severe blow with a bamboo stick would likely cause death, but the intention was not there to cause death. The act of the accused falls under the category of Part 2 of Section 304 of IPC. The accused is guilty of committing culpable homicide not amounting to murder under Part 2 of Section 304. For the reason discussed above, this court finds that the accused Glitstone C.H. Marak guilty for committing culpable homicide not amounting to murder and is convicted under Part 2 of Section 304 IPC. You have understood? Accused? You are hearing for sentence now? When?
The copy be supplied will hear tomorrow, day after tomorrow.
Accused G.C. Marak present along with defense counsel, Srimati so-and-so, prosecutor Srimati so-and-so present. Judgment pronounced in open court in a separate sheet running. How many pages? 41 pages. The accused found guilty for an offense of culpable homicide not amounting to murder and convicted under Part 2 of Section 304 IPC. Full stop. The accused, who is on bail, is taken into custody. Bail bond of the accused stands revoked. Fix this matter for hearing on quantum of sentence when? I don't need to ask for your senior. We will not function at the mercy of your senior. When he's free, then we'll fix the matter. Then please tell us. We are asking for some date. We are not taking your permission.
Idea.
Tell us when a date to her convenience, but not. We will not give you that kind of a leverage or that kind of a leeway that you will choose to fix the date. It's not that we are sitting here idle. Give us a date, we'll accommodate you. Certainly we'll accommodate you. But not this way, that whenever you are free, then only we are going to fix the date. Please tell us, give us a tentative date so that we also will come prepared. Make it Tuesday. Monday, we come down from Shillong.
Tuesday.
Tuesday. Yes. This accused, G.C. Marak. Have you understood? You want to say anything? You've come with whom? Huh? Alone. You are alone. You are a police officer. You know the law. You have been found guilty for an offense of culpable homicide not amounting to murder. Okay? Where the punishment can extend up to 10 years. But we'll hear on your sentence. How much, what should be the punishment, we'll hear. We have not decided what will be your punishment. Okay? We'll hear it on the request of the council. We will hear it on Monday or Tuesday. You want to argue yourself? Do you want to argue on the sentence on your own? Or you and your lawyer should argue? Lawyer? You have anything to say? Huh? Do you have any regret for what you have done? Do you have any regret for what have you done? Or still you say that you did not do?
Said yes.
Huh?
Said yes.
Do you regret for what have you done? Okay, we'll see when we hear you on sentence. Okay? Okay. Fixed for hearing on sentence. Please see that we will not adjourn. We will not adjourn on Monday. Tuesday we are not going to adjourn. Okay. So if you are fixing up any date, if you require to consult your senior or whoever is representing the accused, please do it now when we fix the date. We are not going to change the date. All right. Do that. Do the needful, and please inform the prosecutor also that if at all, if there is some serious inconvenience to you, we will certainly accommodate you, but not at your mercy. Yes, ले जाइए. और कौन सा judgment है? हाँ.
Kalau Lakon Sari, John Sari.
हाँ हाँ.
This is for 313, Your Honor.
In this case, this one the court is expired and they are supposed to produce the death certificate, Your Honor, today, but however they have brought the death summary. But it's not the death certificate, Your Honor.
All right, ठीक है, no
If you
problem.
want to give us time, we'll.
If it is a case where after the death of the accused, the entire proceeding stands abated, then we will require the death certificate. But there are some other accused persons.
Yes, yes, yes. They are both present.
Have we started
No.
recording the statement of 313? What is the charge?
307.
In evidence?
That is an eyewitness as per the statement of the eyewitness.
So we'll do it some other day.
Yes, Your Honor. At the meantime, will give us time also, Your Honor, to produce it.
All right. We are not passing any order that the accused died and all.
Right.
You come with the death certificate, we'll record his death, and then after that, pass an order abating the proceeding against him. Okay. Briefings for 313. Who are the accused persons present before this court today?
Sorry and Lakon Sari.
Yes, next.
Arwan Kindo, Wonderbang, Brewster, Niberko.
What is this? कहाँ है आपको?
Bristol is some urgent work. No, today it's not. Bristol mean.
Who is Bristol? Or
Accusation.
huh?
Accusation.
I don't understand. No, what do you understand? Tell me, what do you understand?
This matter will fulfill on this happen.
Where?
Both Nibalco Alpha now and
You'll file or you have already filed?
on now.
Then file. What's stopping you? Where are these accused persons?
Bristol is have some urgent work. You're not able to come. Nibalco is here.
What's any work? If you don't want to disclose, it's all right. You have your privacy. But can I know what is that urgent work? When the court is waiting to, we have been very kind enough to allow him to go without bail.
Yes.
And you say that you have got some urgent work. What happens if we press the urgency clause here by arresting him? We can bring all his urgent work to naught. Isn't it? What is that urgent work?
He just informed me yesterday evening.
What is that urgent work? I can understand that he has to undergo operation.
Not operation.
And then? All right. Where are these people?
Nibalco is present.
Where is he?
He's here.
Where?
Down there.
He's come for sightseeing in the court.
No.
For what? But if he's an accused, he's come to the court, he is supposed to be in the dock, isn't it?
Yes,
But he's looking at the court building.
he's on the way, but just now he reached.
Oh, say so that he's not here in the court. You also twisting and turning the words. You say that he's there down. He's not come.
He will come now.
When?
Now only he will come.
Now means where? We are now. Where is he?
I will inform him now.
If he doesn't come?
Tell he comes.
No, but if he doesn't come?
He's there and I already signed the affidavit for bail.
How did he sign when he's not come?
He's there only down.
But he's an accused. He's supposed to be in the court, isn't it? Why he's not in the court? Court is such a dirty place that he doesn't want to be there.
No,
You want to sit in some clean place. He's an accused. It's a simple thing. You are a lawyer. Please instruct him properly that he's an accused. He has to be in the court when the matter is being called.
yes.
Where is he?
Now I'll inform him.
Call him. And the police will call him.
No,
Yes, next.
R1K.
Who is the bail? We'll pass order. Call up, none appear. Yes, next.
Lari Kupar.
Hmm.
Neni.
Hmm.
Warke.
Yes, yes.
So, I would like to bring notice of what's on the board. On going through the charge, the IO had charged the accused under the Prevention and Corruption Act, section 13(2)(ab). However, Your Honor, on the basis of the Act, there's no such section that contains the subclause A and B of 13(2).
Bring PCL. You want hearing in this case?
I'd like clarification as the IO had touched it on section 13(2)(ab). However, there's no such clause under 2(ab).
There is. Yes, there is.
13(2)(ab).
Charges are framed for the offense, or charges are framed for the punishment. Charge will be framed for on the punishment or for the offense.
Offense, Your Honor. But Your Honor,
So what is the penal provisions for an offense under section 13? Where does section 13 provides for the punishment? Under section 13(2), isn't it?
and Your Honor, he added the subclause A and clause B.
Yes, A and B.
Clearly added here in the
Yes.
charge sheet also.
A and B talks about offense, and 2 talks about the punishment. Read section 13.
Yes, Your Honor. But there's no subclause A and
There is.
of 13(2)(ab).
Section 13, clause 2 provides for punishment. That's why my first question to you is this: charges are framed for the offense or on the punishment?
Punishment.
So, what is the where is the punishment prescribed for an offense under section 13?
Your Honor, only 2.
Yes.
2, yes.
Yes.
But there's no subclause B and subclause A and clause B.
Subclause A and B, it talks about the offense.
Yes, Your Honor, but this one is
It can be,
13(1).
what is the offense? It can be, say, suppose if a person is charged for rape. Rape has been defined under section 375. Punishment is under 376. So instead of saying 376, 375, the person says that by framing charge that you have been charged for an offense of rape, which is punishable under section 376. Rape is under section 375. Rape has been defined under section 375. So section 13 has got two kinds of offense. Section 13 has got two kinds of offense and two types of offense. One, it has been described under subclause A, and the second one under subclause B. Subclause A says if he dishonestly and fraudulently misappropriates or otherwise converts his own use any property entrusted to him or any property under his control as a public servant or allows any other person to do. This is one part.
Yes,
And the second part is B. Look at the B.
but Your Honor,
If he intentionally enriches himself illicitly during the period of his office, these are two types of offense. 13. So if he does that, then clause 2, subclause 2 provides the punishment. Any public servant who have committed criminal misconduct shall be punished with imprisonment. Now, are you trying to say that this criminal misconduct is not defined under?
no, Your Honor, there's no subclause A and clause B of this subsection 2.
Why not?
The charge sheet, the IO had charged it at 13(2)AB.
Charges will not be framed for the offense, for the punishment. See, section 13 defines criminal misconduct. What constitutes a criminal misconduct has been defined under section 13, clause A and clause B defines criminal misconduct. And subclause 2 provides the punishment for criminal misconduct. So the charges will not be framed for the offense. Charges will be framed for the punishment. Offense is what? What is the offense? Misconduct. Criminal misconduct is the offense. And the punishment prescribed for criminal misconduct is under section 13, subsection 2. So what's wrong? Nothing wrong.
Your Honor, that I just want to argue on one point.
How much time will take?
Now only.
How much time will take to argue?
5 minutes.
Or then it's all right.
You know that the sanction order which has been furnished to this honorable court is defective in nature, Your Honor. Defective in nature, that cannot be accepted, and it's abuse of proceeding of acquiring this sanction, Your Honor. At the first instance, Your Honor, I have received the proceeding where the sanction was sought from the concerned authority. I have received the proceeding where the sanction was acquired from the concerned authority or the competent authority for issuing the sanction.
Okay.
When I perused with this record, I saw that the Superintendent of Police received a letter from the IO of this instant case, bring that prosecution sanction and reference of the case number so and so according with the section. In this, it was found that the IO stated with reference to subject cited above, I have the honor to inform you that the above reference case was investigated by me during my attachment in July DEF in the year 2023 to 2024. I have submitted charge sheet in this case in the year February 2025. The above case is placed before the Honorable Court of July as informed by the public prosecutor. Now, the Honorable Court required prosecution sanction to prosecute the alleged accused person of the case. The alleged accused persons are contractual servants and they were dismissed from the service before lodging the FIR as mentioned by the complainant in the FIR. Prosecution sanction was not accorded earlier as the alleged accused persons were on contractual and they were dismissed from the service. Therefore, I request you kindly request the Meghalaya Basin Management Agency Meghalaya Shillong to accord the prosecution sanction against the alleged accused person in this case. Name of the alleged accused person as well as enclosed format of prosecution sanction. Second is copy of FIR. Third, statement of witness. Then the concerned SP of Jowai forward the same letter to the Deputy Inspector General of Police. Here, the same, with reference to subject cited above, I hereby submit enclosed document as per the prescribed performa, along with a prayer for according pursuit sanction under section 120B, 409, and 420 of the IPC, read with section 7B and 13 2 and AB of the Prevention of Corruption Act. In this connection, I am request you kindly take the matter with the designated authority for granting the prosecution sanction against the accused person named in the enclosed performa. Now, the DIG Meghalaya Police ER again send the same letter to the special SPCID. Here is the main point, Your Honor. Here, that from the DIG Meghalaya Shillong to Special Superintendent of Police CID Meghalaya, prayer for sanction, reference, so and so with the instant case. Sir, with reference to subject cited above, I am sending herewith connected documents and other relevant records of the above case in prescribed performa with a request to kindly move the appropriate authority to accord necessary prosecution sanction at the earliest to prosecute the accused person only for the IPC section. This is how a proceeding was. The prosecution sanction was accord only IPC sanction. That is IPC section. That is section 120B, 409, 420 IPC. It was never accord for the sanction under section 19 of the PC Act, my lord. Your Honor. So here, Your Honor, that is already referred also in the case reference also mentioned name of accused person, address, and provision of law for seeking prosecution sanction under section 197 RPC, Your Honor. It was never been never acquired by the concern throughout the proceeding for the sanction under section 19 of the Prevention Act. So, Prevention of Corruption. Therefore, the same authority, that is Joint Secretary Home Police, forward this again to the competent authority who appoint the alleged accused person. Stated again, with reference to above, please find enclosed here with detailed investigation reports as per the performa along with connected documents in connection with the criminal case. As noted in column 2 is the case reference with request to kindly take up concerned authority for according prosecution sanction against the accused person as noted in column 3, the name of the accused person, under the provision of section as noted in column 4, what is noted, Your Honor, that provision of law for seeking prosecution sanction under section 197 CRPC. So, however, this was the last date was forwarded to concerned authority. If it may take it as it may, it was forwarded on 10th of 11/2025 last year. And surprisingly, I learned that the prosecution sanction was granted by Dr. Vijay Kumar IS, Chief Executive Officer, Meghalaya Basin Management Agency. Granted a sanction under the section 197 for the prosecution of the accused person under section 120B40 of the IPC, as well as the section which is mentioned here, as my learned friends has already mentioned, Your Honor, to prosecute the accused person in this instant case. So my first point of argument, Your Honor.
Sanction.
My first point of argument, Your Honor. So I'm not taking much time.
Give me the sanction.
Yes. Yes, yes.
My first point of argument in section 19, if we take it as it may, now the sanction is given. Take it as a valid sanction. Your Honor, if we go with sections 19 of the Prevention of Corruption Act, it is in the proviso, third proviso said that provided also the appropriate government or the third proviso, section 19, provided also that the appropriate government or any competent authority shall, after receipt of the proposal requiring sanction for prosecution of public servant under the subsection, endeavor to convey this decision on such proposal within a period of 3 months from the date of its receipt. That means from the date of receipt of the competent authority within 3 months of period that they have to communicate and furnish the sanction. As per the record available, Your Honor, the date that the Home Secretary of the Government of Meghalaya forwarded the last request according of the sanction was on the 10th of 11th, 2025. The sanction was granted on the 9th of March 2024, which indicates that the sanction is granted beyond the permissible period as period that is December, February, December, January, February, March, April. It means 4 months after they have received. So if they said that we have received it recently, it is the burden of the prosecution to prove us that. But as what is reflected here, they have furnished more than 3 months, which is mandated as per the section 90 and proviso of the.
All is good. You can go on pointing out the flaws in the sanction order. But we are at the stage of 227, at the stage of framing charge.
Yes, Your Honor.
Now tell me one thing. Can you bring any other documents which is not part of the charge sheet while framing charge? If yes, please show me the law.
Yes, Your Honor.
Can you bring any documents which is not part of the charge sheet while framing charge?
Let me explain, Your Honor.
No question of explanation.
Yes.
I have to exercise my power under section 227.
Yes.
Now, while exercising my power under section 227, what will be the new provision under the BNS? It may be. We'll just go to the old act.
Yes.
I have to exercise my power within the 4 corners of the section 227.
Yes.
If you are praying for discharge. Charge sheet has been filed before this court.
Yes, sir.
Prosecution will open up the case.
Yes, sir.
Prosecution had opened up the case.
Yes, sir.
It was brought to the notice of the court that one very vital document or the statutory requirement under section 19 was not complied. As such, this court does not have the power to take cognizance of the offence and prosecute you in absence of prosecution sanction. Now, it is not your case that after filing charge sheet, sanction cannot be obtained.
Okay.
It's not your case. They have procured the sanction after filing of the charge sheet. Now, you have got hold of the documents which went into the making of the sanction order. That is not part of the charge sheet. That's not part of the charge sheet. Now, can you rely on those documents at the stage of framing charge? Only this much. Any document which is not part of the charge sheet, can you rely on those documents?
I will explain to that now.
Yes.
In one aspect, I say yes, no, I cannot rely on those documents. The other aspect, Your Honor, this is not a traditional case. It is a special case. Special case, we are trying under the Prevention of Corruption Act.
No, let us be very clear. Otherwise, we can go on and on and on. Let us be very clinical on the matter.
Yes,
we can go on.
Yes, sir.
If you're saying that it's a special case,
yes.
What is the procedure for adjudicating this case? Which procedure? Does the PC Act provides its own procedure?
No.
Which procedure do we follow for trying? So again, we come back to same. While framing charge, we'll follow the procedure prescribed under section 227, isn't it? So it may be a special act.
What I'm trying to say.
Yes. Confine your argument to the query put by the court to you, whether we can look into any other documents which is not part of the charge sheet, for at the time of framing charge?
Yes.
Can we look?
Yes, I have it.
Even for that matter, if the prosecution wants to bring any very vital documents, if it's not part of charge sheet, can we look into it? Same is with you. You may be in possession of any documents. All right. You may be in possession of certain documents which may falsify the prosecution case at the threshold. But then before you produce those documents and convince this court, first you have to satisfy this court that this court has the jurisdiction to look into those documents which is not part of the charge sheet. And if I have, then I look into it. But
Yes,
if I don't have the jurisdictions, even if this documents is of great importance to you, still I don't have the power to look into it at this stage.
Yes.
So please satisfy me that if I can look into a document which is not part of the charge sheet at the time of framing charge. And if yes, then I will give indulgence to those documents.
No, Your Honor.
Yes.
Actually, what happened, I have received this document from the court itself. So I refer to it as because I just want to highlight one point. Procedural sanction is a precondition, has to be compliant before we taking the case into cognizance. So in the
Does it say that the prosecution sanction
Yes.
can be examined at the time of framing charge,
Yes, Your Honor.
whether it was in accordance with law or not? Can
Yes,
we
Your
do
Honor.
that?
Yes, Your Honor.
Show me the law.
I have a law on that.
There is only one judgment 2018, which says that we can look into some documents which is not part of the charge sheet if those documents are of sterling quality.
Mhm.
But recent judgment of the Supreme Court said no, that we cannot rely on any other documents other than the material in the charge sheet.
This decision from the Supreme Court, which says that the prosecution sanction cannot be interfered with during the argument stage, framing of charge stage.
What's that, please?
State of Karnataka versus Lakshman Rao Peshwe.
See, I have not gone through that. It's okay, no problem. But my only point of argument.
Yeah, all right. He says that what does it says that prosecution sanction?
Cannot be interfered with during the framing of charge stage.
If the prosecution sanction cannot be interfered at the time of framing charge, interference will be on the point of scrutinizing it.
Yes.
Now, if you find that the prosecution sanction is no sanction in the eye of law, or it does not have any semblance of being a sanction under Section 19, then we are not interfering. We say that these are not sanctioned in the eye of law. Then it is no sanction. But scrutinizing it and attaching any kind of a conclusion, that I'm a bit apprehensive whether we can do that or not.
Yes, one thing I agree with my learned friend. He said that we cannot question this prosecution sanction at this stage. Now, I have questions on the proceeding that how we obtain the prosecution sanction. I agree with my learned friends that I will not question on anything on this because we will not ask this person. That's a question of trial. But as of now, what is the proceeding that has been followed to acquire the sanction? Now the question is, it was never been asked under Section 19, Your Honor. It was never. It's asked under the sanction was asked under Section 197. So if we say that the accused person fall under the mandate of 97, that is totally wrong. The scheme of 197 and 19 is different. That is my argument. How the sanction was acquired, despite Your Honor have given the ample time to the prosecution, and how do you follow the procedure? Procedural lapses, and through that they have acquired this. And how they acquired, never been asked for Section 19 under the PCR. So if there are
You mean to say, suppose the person is asked for a sanction, who is supposed to grant sanction?
which section, Your Honor?
Who is the person competent to grant sanction? Is a person who
It's
can
different.
remove him from the office.
Yes.
He's the competent person to grant
Yes, Your
sanction. Now that person, after examining the records or after looking at everything, he finds that no, though sanction has not been asked for these penal provisions, but looking at the materials, everything, he applies his mind and he grants sanction.
Okay, Your Honor.
So what's wrong? Rather, it goes against you
Yes.
that he has not mechanically granted sanction. Though these sanctions was not asked under Section 19, but he, after examining the matter, he had applied his mind and granted sanction in 19.
Yes, okay, Your Honor.
Which shows that he did not mechanically grant it and he was not acting like a post office, that
Okay.
whatever has been asked by the investigating officer or the superintendent of the police, he has just accorded that without applying its mind. Though the sanction was under section 19 was not asked, but he granted sanction because this itself shows that he applied his mind.
Okay, Your Honor. No, why?
Whereas it says that whatever is asked by him, he has to give.
Yes,
He
Your
can
Honor.
apply its own
I
mind. He
will
can
provide
refuse
that, Your
it.
Honor.
He can add something.
Your
He
Honor.
can say that the materials are not there.
Yes, Your Honor. The person
Yes.
who grant the person who grant the sanction, he even grant sanction under the IPC. He doesn't have he's not a competent authority to grant the sanction under IPC 197. He even grant the punishment for IPC also. He said that section 120.
Which section under IPC requires sanction?
197, Your Honor.
What is the section charge against them?
It's 120B, 407.
For
and
120B,
420.
sanction is required.
No, because it's mentioned here clearly.
No, for IPC, what sanction is required?
Sorry.
The penal provisions under IPC, is there any such provisions like we have under 121A? Sanction is required, waging war against the nation. But for 120B, sanction is required.
I'm just perusing the sanction.
Alright,
Isn't
alright.
that while acting or purporting to act in discharge of official duties? That means these people are governing under section 197. So whatever it may be the section charged against them, but as per the sanction stated that these people are fall within the mandate protection of 197.
I agree, you may have a point, but at this stage, can we look
Yes,
into
yes
it?
or no? Because
These documents which you are arguing, do you think the prosecution is in possession of these documents?
I don't know. I just received it from the court, from the prosecution.
The
Yes.
manner in which the sanction was accorded.
Yes, yes, sir.
Where is that? Where is the copy? Where is the copy with us?
You see, baby, now.
It's already on 11.
Where is the copy? The copy which you are referring to is part of the record. Show me. Show me the copy if it's part of the record. No, all those documents which you are referring to, the documents you have referred to, starting from the request by the investigating officer to a court sanction, and it travels up to the competent authority. Where is that? This one? This one? Okay. And the prosecution has this copy? Prosecution has the copy? Then we strike down the charge. If you have the copy as part of the thing, then we strike down. This is not the way you grant sanction. Just because sanction, the law says that sanction has to be granted, you just don't dump the sanction in the court.
Yes, they have.
How has it come in the court? All right.
This is just placed because the court had asked for the letter, because there was a hearing. I have stated for its honorable court that sanction was.
All right. Satisfy me only one thing, that we can look at the legality of the sanction order at the time of framing charge.
First, you know that the.
No.
Sorry.
Please try to understand. We have to function in accordance with law. Before there may be a palpable illegality. But then the question which should be first needs to be determined is that whether we have the authority to address that illegality.
Yes, sir.
If yes, show me under 227 I can do that. You may have all the arguments, which may sound very impressive, but does the court have jurisdiction to entertain your argument and pass appropriate order? Satisfy me on that first. Under 227, can I examine the legality of the sanction order? Can I do so? If yes, then we are interfering. We will not allow such sanction orders to form the basis of prosecution. Only satisfy me that I can do that at this stage.
Yes, Your Honor.
Show me. Do you have some citations?
I do not bring it, Your Honor.
No, on what basis you say that I have the power to do that?
With regards to procedural sanction, if upon consideration of the records and the case and the documents submitted herewith, we are concerning only with the prosecution sanction, not with the case, the police report. As per the, as I have already submitted, how the prosecution sanction was granted, it was
Yeah, absolutely right.
mechanically granted.
You're absolutely right.
Yes, Your Honor.
That
And all the procedure.
you're not getting my point. Please read section 227
Yes,
of CRPC.
After hearing the submission of the accused and the prosecution, in this we have the judge consider that there is not sufficient ground for proceeding against the accused. He shall discharge the accused and record his reason for doing so.
There is no sufficient ground to prosecute. Now
Yeah.
tell me that from where you can bring your argument that this prosecution sanction will come within the purview of no sufficient ground.
It was mechanically granted, Your Honor.
See, please try to understand. At the stage of framing charge, we will not evaluate the evidence.
Yes, not evaluate the evidence, Your Honor. See, this is a
We
precondition.
will not attach conclusion. We will not appreciate the evidence.
Not the evidence of
The
the case.
evidence has to be, this is an evidence. We will not appreciate the evidence. The evidence has to be appreciated during the course of trial, not at this stage.
Yes, I agree very much. I agree 100%.
Yeah.
I never touched anything about the evidence of the case, Your Honor.
Are we not
The
appreciating
question
the
is,
evidence?
these are precondition. Precondition that is not, it is, as we have already, Your Honor is very much versed with the doctrine of substantial compliance. These are precondition which have to comply with all or not at all. Because it's precondition, then we can prosecute the accused person. If not, then you have to vitiate. So from that aspect, I'm not saying from the evidence
Is this
aspect.
document prosecution sanction which is placed on record?
Yes,
Is it not sufficient compliance?
it's not sufficient compliance, Your Honor.
When can we say that it's not sufficient compliance?
Never been asked for section 19. I never been
Who
asked for
says so?
in the records, Your Honor.
Which record?
This record which have been submitted by the court, Your Honor, to us, supply.
But it is culminated into a sanction under section 19.
And sorry, Your Honor.
It is culminated into sanction under section 19.
Why? That's why. Because of that, now I understand that because sanction, the person who issued this mechanically issue it because even he exercised power under section 197 also. 197 is totally different. It's a different scheme from 197 and 19. That's mean what does it shows? If he grants sanction under 197 CRPC means that he doesn't understand what is the case.
What is the difference between 197 and 197?
Your Honor, 197 is very much Your Honor, that is applicable only to those judges, magistrate, and public servant which cannot be which are not removed. Sorry.
You tell me what difference under 197 and 19? You produced the judgment, na?
Yes.
You have produced the judgment where it distinguished between 19 and 97. You did not read your own judgment. You have produced that, that's Swami's case. Anyway, you see, please, you are not getting my point. We are virtually getting into the appreciation of the evidence. What has gone in the making of this order? What has gone in the making of the sanction order? That is subject matter of the evidence.
You know, if even the central government have only issued guidelines regarding the sanction order granted. If you want copy, or no, I'll just give it. Because there are different procedural lapses which did not follow, and prosecution was mechanically granted.
So now all is good. Please try to understand one thing is that all your arguments with regard to the illegality or the procedural lapses while granting the prosecution sanction can be entertained only when you cross the first hurdle of section 227. That the court in exercise of jurisdiction under section 227 can look into some materials, all right, which is or rather the prosecution sanction when the prosecution sanction is illegal on the face of the record. If that is the case, then we will certainly look into it. First, you have to satisfy that whether we can do that. Show me the guideline. Put up all this together.
There is one case which I have not gone through because due constraint of time. It was fixed the first day and I could not read. There's if I'm not mistaken, CBI versus Ashok Agarwal versus Ashok Agarwal 2013, if not mistaken, that in this, if the sanction is mechanically granted and did not provide all the follow procedures as provided by the concerned department of the government, and then the sanction is deemed to be void, and the court can quash and rescind the sanction at instant, Your Honor, before we proceed with the trial. So, but I have not gone through much. I cannot bring it as of now. CBI versus Ashok Agarwal, if not mistaken, that the case. This continue, I do not bring it, Your Honor. It has, this is not the manner how prosecution sanction is given.
Then we'll take it up Wednesday, because we can't delay the framing of charge.
Even in this, Your Honor, that how sanction has to be sought, it is only provided to all the state and unitary of India, and this is the format that they have to follow. In the last para annexure, Your Honor, last 2 pages, page number 6 and 8, 7 and 8, and 8 of 8.
Okay. Yes.
So, Your Honor, I just
give me that decision, so that you can give it.
I did not bring it, Your
Would
Honor.
all this make a one photocopy of all this?
You can keep it, Your Honor, with you.
And the other was stacked together. This is what he's talking about. Okay, we got your point, but we just try to convince us that under 227 we can, and while exercising power under section 227 of CRPC, we can look into the sanction order and the legality of the sanction order.
CBI versus Ashok Agarwal.
I believe I have gone through that judgment. So what you do is that you just satisfy us that we can look into the correctness of the sanction order at the time of framing charge. But then you are not disputing those documents which he is relying on.
Actually, I like produces.
So that is a part of the sanction order. Okay.
No, this was never issued at the time when I brought the sanction order. Your Honor had asked an assurance from me whether I have sought the prosecution sanction, and this is what I have brought on record. It's never made part of the sanction order. This is just an assurance to the court that we have seen the prosecution sanction.
What is the amount, Mr. President?
1 crore.
No. 14 lakh would be.
14 lakhs.
Yes, 14.
Refund or discharge?
Put on.
Refund the money, will discharge. Are you willing to refund?
No, Your Honor. We did not do that. We have permitted.
We can use the clause of plea bargain and let you go. This is for government of this is for central government.
Yes, central government.
The state government has provided some guideline for.
So government is always sleeping, so they forward to each and every secretary of the state concerned state. This is the procedure where they have to follow while according the prosecution sanction. We don't even get it from the government. We have to get it from the website from the central government.
Okay. We'll look at it when, give me next week, because we can't delay the matter. Charges has to be framed within 2 months for the filing of the charge sheet.
Okay.
And there has been a considerable delay. So that's why we are fixing these matters at a very short interval. You satisfy, then we look into all these things. If you can satisfy under 227, I can look into all these things, then we'll certainly look into everything. Only on that point you satisfy that while exercising power under section 227, we can also examine the legality of the sanction order. Suppose, I can give you one example also, you can draw an analogy. Suppose it is a case where the charge sheet has been filed on the second FIR. Okay. Second FIR is no FIR. So charge sheet filed on the second FIR is no charge sheet in the eye of law. So whether that can be argued at the time of framing charge, because the entire case falls if the investigation was carried out on the second charge sheet or second FIR. So similarly, if it is not that if the prosecution sanction on the face of the record appears to be accorded in total defiance of the procedural safeguard, then we don't need to send it for trial. It can be thrown out at the threshold. That you satisfy me only on that. That if the legality is so glaring that it does not require any scrutiny, just on the face of the record, it flies. So if that is the case, then under 227 we can look into it and throw it out. If there's no prosecution sanction, then still you are not free. Is there any IPC there?
Yes.
Yes, Your Honor.
Then we have to send to magistrate. If there is no sanction for prosecuting you, then you have to go to the magistrate. Still, you can argue whether there is no such offense for that also. Anyway, that's beside the point now. Now, only thing is that we have to see whether the sanction is there now. Put this one. Put it properly so that I can all this make one compilation. So I want to go through it. Who was the sanctioning authority?
The CEO.
Huh?
CEO of that basin.
Who is the
Chief Executive Officer of the basin.
We'll call him as PW1.
That's a matter of trial. We do not, Your Honor.
You'll be in the best position to ask these questions, and when it comes by way of evidence. Anyway, we'll see that. You should be very happy that you get a chance to cross-examine him.
It's only vitiated. As far my point of view, it's only vitiated.
Okay, we'll look
It's
into
no
it.
point of asking the question.
Only on the question of jurisdictions and the scope of 227. And whether we can do so, we can look into it. All right. I heard learned counsel. So you are representing whom?
Nini.
Prosecutor so-and-so present. Our learned counsel, Sri so-and-so for the accused, Nini Pakma.
Yes,
And
yes.
you are representing only Nini Pakma?
Only for one person.
Nini Pakma. Learned counsel has raised a very contentious argument, questioning the legality of the prosecution sanction accorded to prosecute the accused person under section 9, prosecute the accused person under the PC Act 1988. Learned Defense Counsel has placed a guideline dated 18 October 2024 rolled by the Ministry of Personnel Public Grievances and Pension, our Department of Personal Training, our Government of India, which outlines the procedure to be adopted for according sanction under the PC Act. Thereupon, hearing the learned counsel, this court finds that the larger question which looms is whether the court, in exercise of power under section 227/228 of CRPC, can examine and give finding on the legality of the prosecution sanction order. Stop. The defense counsel shall satisfy this court, keeping in mind the scope and power of the court under section 227 of CRPC. This matter will come up again on Wednesday.
Your Honor, actually,
Come through BC.
I beg Your Honor, if you consider me on Tuesday, because I take leave on Tuesday from my station.
Tuesday.
Any
Is
Tuesday.
it okay Tuesday? Tuesday.
Much obliged.
And what about the other accused? Learned counsel, counsel, Srimati E. Pasa, present along with the accused. Know your name? She has also raised an issue, and she has also contended that charge sheet has been filed for an offence which does not find place in the statute book bracket PC Act. Her contention shall also be examined. Your part? What do you want? Nothing. So we'll frame charge against you.
No.
Tell. What do you want? बोलिए. हाँ. बोलिए. Tell, what do you want?
I have the argument of my learned friend, Your Honor.
Learned counsel, your good name?
Dishadong.
Dishadong. For the accused, you are presenting whom?
Lariko Pabang.
You file petition?
Discussing, Your Honor.
Has filed a petition number 41/2026, inter-alia, praying for dispensing the personal appearance of the accused for the day. On account of his professional engagement, as a personal appearance, dispensing personal appearance of, for the day. On account of his professional engagement, prayer for dispensing the personal appearance is allowed. Fix this matter. Fix the date on such says for further hearing before consideration of charge. Okay. Okay. Yes. Yes. MACT.
Tambah langsung ya, case number 2, 2021.
Your Honor, in this instant case, I could not file my evidence on affidavit today because I'm supposed to file the evidence of a doctor who conducted the post-mortem. So I inform and I call the IO of this instant case with regards to the original post-mortem, which is in his possession. So I called him several times, but he's not responding. So I pray a summon may be issued under Section 94B. And
Issue summon.
yes, sir. Yes, sir. Summon may be issued.
You are for whom?
Just number 1 and number 2. MAC number 2 and MAC number 3.
Same witness.
Yes, the same. Yes, the
Issues
same.
have been framed.
Yes, I've already filed the other PWs also. Other
So
witnesses.
learned counsel, Srimati S. Kindia for the claimant present. Learned counsel A. and Rambai for the OP insurance present. Learned counsel for the claimant submits that this matter is fixed today for CW.
Yes, CWs of the doctor.
The claimant could not secure the presence of CW4,
CW 5.
CW5, who is a police officer. As such, the claimant seeks the assistance of this court to secure the presence of CW5.
So I just want to make a clarification. CW5 here is a doctor, but the post-mortem is in the possession of the IO. So CW5 is not a
This
police.
case was registered where?
Clearance. So
From the police you
CW5
can
of
get
a
it.
doctor.
It will remain in the case record of the case, isn't it? Why don't you apply certified copy?
No, I had to talk with the other counsel at Clariot. They called this IO. They said it is
Matters
not
under
in the court
investigation.
record. The original post-mortem, it's not on record. It's in the possession of the IO.
Barabar Mase? Why is he keeping these records with him?
That's why I. So CW5 will be the doctor.
Whom do you want to summon?
I want to summon first the IO so that I could collect the original post-mortem from his possession.
Presence
Then
of
on
the
receiving the original,
CW,
then
IO will be CW6.
I think so, 6 or 7.
Someone CW6. Give the name, huh? Give the name of the IO.
DD Vardri, SIDD Vardri.
He's a police officer. And now posted where?
Umpleng Police Outpost, East Jaintia Hills.
Is you summoned to the IO?
Yes.
Fix for evidence. Same order?
Yes, sir.
Yeah. Then number 3.
On in this case, we have filed evidence of just few more left. The medical officer from Negrims. Actually, he had just put his signature. There is no identification towards the name. We tried contacting this hospital. They said that they're not aware about the signature. Right? We'll have to take fresh steps, to verify the details of this doctor.
How many deposition you have filed?
I have filed 1, 2, 3, 4, 5.
Then why you don't start calling them for cross examination?
Something has crossed,
That's one. Doctor.
Call them also in the meantime, you can bring them also, the other witnesses. Also. All right.
Your Honor, with regard to the police, if he had come on the same day, we better reflect my order also. Same police.
We can pass when he comes. Will you make a request that he's a witness in your case? All right. This,
Just say we had had a word with him that he said he required someone.
okay, he's coming in this case. We can once he comes, we can examine him. We can use him as a common witness. Yes, this item number 3. Counsel for the claimant LS Yambon present and prays for further time to file the deposition of the CWs. Pray aloud. This OP incident is also present. Then this item number 4. Kadu 5.
456 has been adopted.
Yes, please tell me. What is this matter fixed for today?
For evidence or cross-exam by the witness is present today.
Present.
Yes.
These 2 witnesses are common for all the case.
Yeah, yes, sir.
For all the case.
Not all the good. They are a claimant only. Same case for they are a claimant.
They are the claimant in 5, 6, 7.
Yes. No, one claimant for one case only.
They are claimant. This witness is claimant in which case?
Number 4 today. 4 and 3 on. 3 and 4 on is today for the evidence.
No, go on the serial number, not on the case number.
Number 3 is this Panchayat file.
He's here. He's here.
Yes, he's here.
And Khadu Pai?
Khadu Pai is already done.
And who else is there? Filmi Pai?
Filmi Pai is today.
There?
Yes.
And
the genius Pai is already done last time.
Done?
Yes.
So in Khadu Pai, what order do you want?
Yeah, I don't know what. Let the cross except on the cross exam.
Khadu Pai already cross.
All
Yes,
the
no,
PWs
not
cross.
all.
Then?
They have to bring some more witnesses.
Who are the witnesses?
You know, we file 5 witnesses, including the claimant.
Yes.
So, except the doctor and IO, have not. Will combine. Will club with the Madam Sinsar, because since IO and the doctor will need the same evidence with them. So,
no, the deposition which you have filed on behalf of the claimant in this MSc case number 2 of 2025. The witnesses, all the witnesses have been cross-examined.
No.
How many more left to be cross-examined?
4 witnesses and one claimant.
4 witnesses are left to be cross-examined.
Yes, sir.
Why you don't bring them?
No, because some of them they have some personal work and some of them.
No, bring them.
Next day I'll bring all them.
How many witnesses have been cross-examined?
2 witnesses.
In this item number 2, MSCT case number 2.
2 is Khadu Pai already cross.
One witness to cross.
Yes, sir. This claimant.
All right. Learned counsel for the claimant E. Manso, present. Learned counsel for the OP insurance A. and Rimbai, present. This matter is fixed today for further cross-examination of CWs. Learned counsel for the claimant submits that there are 2 CWs, that is the doctor and the police officer, who is yet to be examined. This court has already summoned the police in a connected matter. The counsel for the claimant prays that the police may be allowed to be, the police officer may be allowed to be examined as claimant's witness. Prayer log. Fix for evidence. Same order, all this.
Yes, sir.
The doctor and the
Yes, sir.
police. You want to
Yes,
examine the
yes.
police.
Yes, sir.
Same order. Then. All five. In this Panchai Bhai also. No. Panchai is here today.
Panchai is here.
Bring. No, Panchai don't pass an order. What?
Palma bail today.
You know, is here before us.
Yes.
Tell now what do you want?
Grant a bail.
Huh?
Grant a bail.
You refuse. This is what is we are granting some government schemes of it. You have to earn bail. You have to make out a case for grant of bail. How can we just grant bail on mere asking? You have to satisfy us that the case made out for grant of bail.
You are not the bail policy. You are not the applicant is the resident of local region. But is a resident of local region.
Is the what?
Local region.
Hmm.
You undertake to present before the court whenever required. So I pray the court to grant their bail condition. On behalf of the brave Star Minister, is also the permanent resident of Munso village, and then he ready to cooperate with the court also, whatever apparently needed. Pray the court to grant him bail.
In which case?
This criminal complaint number 1/2025.
What is the allegation against you? What is the offense charge against you?
Yeah. The alleged that a seized gold was seized from the vehicle of the accused.
So I mean to say, what is the penal provisions invoked against you?
Yeah, section 188 IPC and section 21 MNDR.
What is the punishment for both the offense?
This 21 5 years.
Huh?
5 years.
Read.
Section.
Whoever contravene the provision of subsection 1, subsection 1A of the section.
What are you reading?
This 21 penalty.
Huh?
Section 21.
The complaint has been filed for an offense under which section?
188 and section 21 MNDR.
Read section 118. What is the punishment?
Disobedient to order duly promulgated by public servant. Whoever knowing that by any order promulgated by public servant lawfully employed to promulgate such order is directed to abstain from certain act, to take certain order with certain property in his possession or under his management, disobedient such direction.
What is the punishment?
1 month, Your Honor, with fine 200.
Plead guilty and go home. Huh? Pay 200, go home. Huh?
What? Section 21, Your Honor.
Oh, sir. 21 also is there.
Yes, sir.
Read what is the punishment for 21.
What it is, section 21, Your Honor. Whoever contravene the provision of subsection 1 or subsection 1A of the section 4 shall be punishable with imprisonment of a term which may extend to 5 years or with fine which may extend to 5 lakh.
Section 23A.
Compoundable offence. Yeah. An offence punishable under this act or any rule may either before or after the institution or the prosecution be compounded by the person authorized under section 22 to make a complaint to the court with respect to that offence or payment to that person or credit to the government of such sum or that person may specify.
Who has filed complaint in this case?
The police.
He's above the rank of sub-inspector?
Yes.
Yes.
He's a sub-inspector.
That means he is the competent person to compound it. You are willing to compound?
Yes, sir.
Compound. We'll consider your bill application as compounding application. How much you'll pay?
The board accused report only 50,000.
Huh?
50,000.
Both, then we will close the case. Pay 1 lakh, we'll close the case. Pay 1 lakh, all three of you will close the case.
Oh, for my accused also? Your Honor, as of now, we have not come yet to that portion because one of my accused is Arlanki Arbat Kilindo. It's being arrested on the strength of NPWA. So I understand that they have come from a very poor family, and that's why they are earning this work for earning a livelihood to educate their children. Actually, indeed. So regarding that aspect, to compound with that a huge amount, so I need to talk with them. Because as of now, we have seen in the market, it's very less work and very less business going out in and around in the Jaintia especially. So we have seen the difficulty that's suffered by the common people on the society itself. And in this season, it's a sowing season where they have to spend a lot for agricultural purposes. So therefore, a time to be given to discuss with them.
Okay, take your time.
Yes.
Bill application. Your one is bill application?
Yes.
Bill application.
13 or 14 times.
Bill application number, the bill application mentioned above, the bill applications mentioned above, you keep all the three, no? It's taken up for disposal by a common order. In as much as all the three bail application, it arises out of a common case.
Yes.
And the accused persons are similarly situated. Full stop.
4 bill has been filed.
Huh?
4 bill, no?
4.
Yes, for Wonder Bank also. For Wonder Bank, it's a bill application number 12,
Give the name
2026.
All right.
And for this R1 killing dog, it's bill application number 11, 2026.
You give the name of all the counsels for whom.
Yes, yes.
All are prosecutors. All right. On perusal of the record, it appears that a complaint case has been filed against all the three accused persons, all the 4 accused persons, namely Soma, under section 188, under section 21
21 years.
of the MMDR Act 1957 57 stroke 188 IPC. Full stop. On perusal of the facts and on perusal of the material in the complaint, it emerges that they were not arrested, accused.
No, yeah.
Accused persons were never arrested.
Only except this R1K Lengdong
How?
on the strength of
Why
NP.
accused persons were never arrested during the course of investigation,
Oh, yes, yes.
which is a clear indication that the custodial interrogation of the accused persons was not necessary. Stop. Not necessary at the investigation stage. Stop. Next paragraph. This court, after taking cognizance of the offence, was pleased to issue summons to the accused persons, to all the 4 accused persons. The accused persons failed to appear. Consequently, coercive step was taken to secure the presence of the accused persons. Full stop. Pursuant to the non-bailable warrant, to the non-bailable warrant issued by this court, the accused, what's the name of the accused who was arrested?
R1K Lengdong.
R1K Lindo was arrested. However, he was allowed to go. No, however, he was not taken into custody. Prosecution has an objection. Learned prosecutor fairly submitted that detention of the accused persons in custody is not required, is not necessary. As such, he does not opposes the bail application. Stop. Ordinarily, when the accused is not arrested during the course of investigation, or if the offence is bailable, a detention of the accused in prison would not be necessary. In case in hand, the punishment for the alleged offence bracket section 21 MMDR Act can extend up to 5 years with fine of rupees 5 lakhs. Which makes the offence non-bailable. Next one. Even otherwise, the law laid down in Anish Kumar clearly spells out that in cases where the offense where the punishment for the offense can extend up to 7 years, the accused is entitled to the statutory safeguard envisaged under section 41A. What is the corresponding section in the BNSS? 41A? 41A.
BNS. Which section?
CRPC 41A.
41.
Stroke section 35. BNSS. The prosecution and the investigation is silent about the ground of arrest. They is silent about the need of arrest of the accused and compliance of section 41A of CRPC. This court finds detention of the accused in custody would amount to curtailing the liberty without any lawful justification. Full stop. The accused give all the information are enlarged on bail on execution of PR bond of rupees 20,000 with 2 sureties of like amount and on the following condition. The accused person shall appear before this court on the date fixed and stand for trial. The accused person shall not influence any witnesses or tamper with the evidence. Full stop. The accused person shall not leave the jurisdiction of this court without the permission of this court. All the 4 bail applications mentioned above stands allowed and disposed of by this common order. Yes. Yes.
Call witness, John.
All right. This one second. This your accused where? No, where is your accused?
One is legal words of express.
Just add one sentence. It is pertinent to note, take note that all the 4 accused persons are present before this court and present before this court and in the custody of the court, which is one of the precondition for invoking the jurisdiction to grant regular bail. Stop. Unless the accused is in custody, regular bail application cannot be entertained. Then what do you have to say? You? What do you have to say?
Because due to the
If we dismiss your bail, you've read my order, no? Can we entertain bail application? Are you moving anticipatory bail?
no, no.
A regular bail without custody can be granted. First, you have to be arrested, then bail, na?
Yes, sir.
Where are you? Have you been arrested?
No, no.
And then how can we grant bail to you? Can we grant bail to a person who has not been arrested? Yes, we can grant. That will be anticipatory bail.
Yes.
But regular bail, how can we grant if you are not arrested? Arrest means custody. If you surrender also is arrest. That means you are in custody of the court. From here we release you. Then what to do? How do you handle this?
Pray the court to allow, because today this is emergency.
Emergency.
Yes, there's some urgent work.
And we will press this emergency button. Then you'll go to jail. No, please try to understand. We are not in some kind of a joke.
Yes, sir.
We are in some kind of a serious legal proceeding. How can we grant bail to a person who have not appeared before this court and who is not in the custody? You ask him to sign before I sign the order. If not, I'm modifying the order. I'm dismissing a bail application only on this ground that you are not before this court. And we have made it very clear. We can't invoke our jurisdiction to grant regular bail until and unless the person is in custody. Custody can be by way of surrender also. Either you are neither arrested nor you have surrendered before the court. How can we grant regular bail to you? Okay.
Yes.
Before I sign this order, if you have not,
Yes,
all the accused will sign in this order,
Yes.
showing that they are here present in the court.
Yes.
Okay.
Yes.
And if you don't sign, we'll modify this order. Only your bail application will dismiss.
Yeah.
That it cannot be entertained because you are not in custody, or you are neither in custody nor you have surrendered before this court. They have all three have surrendered. Okay.
Yes, sir.
I tell him whatever emergency work, this is also emergency work.
Okay.
Okay.
Good enough.
Yes, bring the witness.
Regarding the PR bond could be distributed later on, we have ready for.
Let me sign the order.
Yes, yes.
Yes.